Hi, John. Hi. Hold up a sec. Let me
How's it going?
get this out of the way. I think I am ready.
All right, let me get my stuff ready too.
Yeah, I'm
Okay.
so sorry. I got confused with the time. I am so sorry. How are you doing?
Good.
Good. And I was just getting ready to go. But I was actually in a meeting earlier, and then I realized that you had texted. So I'm so sorry about that.
No, that's all right.
All right, but there's a lot. How you been? You're looking good. Looking sharp.
Thanks.
Full of black.
Yeah. One of those days.
Yes. Let me turn this up and welcome to another episode of the NeoLiberal Round Podcast. I am Renaldo McKenzie, your host and creator, and I have with me Mr. John Anthony Castro, who provided the insight behind the show, the Castro V Trump. But we're not only going to be talking about Castro v Trump, because there's quite a few happening today as it relates to Trump in Colorado. And I wanted your expert opinion. I wanted you to provide insight. And I did tweet yesterday that, I was going to ask you whether or not you believe that your case, the Castro v Trump, helped to inform the case in Colorado.
Oh yeah, absolutely. So first, I want to give some background. That way, people kind of know, kind of what happened and where the cases are at. So initially, what Crew was doing is they were handling the state level part, right? So I'm a federal practitioner. I'm a federal tax attorney. I practice in the federal jurisdiction. So I understand federal law, the federal rules of evidence, federal rules of civil procedure, all of that stuff. My strategy was number one, to run for the office of the presidency, first and foremost, because I've always wanted to. And then secondly, by doing that, I would have what's called Article 3 standing, an actual personal injury, a competitive injury, to sue Trump. And so the concern there that some legal scholars had is they said, well, all of the whole case hinges on you, pretty much. If something were to happen to you, like God forbid, I get shot or something like that, all the cases would effectively fizzle because it's all based upon one person. And not only that, but they were like, you'd have to convince the doctrine of political competitor standing isn't developed enough. And there's a lot of wiggle room for judges to try to argue that you are on the ballot, but you're not really competing. You don't really have an actual injury. But at that time, I kind of viewed that as, no, I don't really think they can go there, because once I'm on the ballot, I mean, that's it. I have a campaign website. There's no question I'm competing for votes. Little did I know, how rigged the system is. And so the strategy that Crew was pursuing was state level. What they wanted to do is they wanted to use state law and state statutory frameworks that allowed for voters to bring eligibility challenges to candidates for public office. One of the concerns that I saw with that is that the election clause in the United States Constitution specifically limits state involvement to elections involving representatives and senators. It doesn't say anything about a national election for a countrywide office, and the only one that we have is the office of the presidency of the United States. So my concern there was that states didn't even have a jurisdiction to make eligibility determinations with regard to nationwide candidates, which the only contest for that is the presidency. The other concern was that the courts could argue what's called federal preemption. Federal preemption means that this isn't even an issue that the state is allowed to pass judgment on, because questions of treason and insurrection stem from the U.S. federal Constitution, and so it's a question of federal law, and so only a federal court could express an opinion on it. So those were the concerns that I had about Crew, and then of course Crew had their concerns about my claims as well, and that's kind of where everything kicked off in September. I started filing suits left and right in state courts or federal courts, sorry, and the reason I did that is that I'd had heard time and time again, oh, we got him, and I was like, I'm tired of this. I want to do something myself. But I also decided I'm going to stay in my lane. I'm going to stay in federal courts. I'm not going to do the state court stuff. I initially started a little bit in state court, but I realized like that I don't know state law like the back of my hand like I do federal law. So I decided I'm going to stay in my lane. I'm going to stay in federal courts. Crew's going to stay in state courts, and we'll see how things play out. Of course, Crew had been working with Colorado on this for quite some time, right? So they made sure that they had the right voters, that they had the right judge, and they pretty much had a pathway to the Supreme Court, and it worked, and that's great for them. I'm happy. The Supreme Court's agreed to take the case. It doesn't mean that it's the end of the story, and I'll explain why right now. My cases are still pending in federal court. So I relitigated the New Hampshire case. The New Hampshire case now, the evidentiary record shows actual substantive campaign activities. And I mean, they're going to argue that it's minuscule. And Trump's own expert already admitted that I would be impacted. He said that my vote allocation would change from 0.00001 to 0.0002. You know, obviously, making a joke at it. But what he didn't realize is all I needed in the evidentiary record was proof that I was adversely effective. He admitted that. And so all of this is now going to be redecided by the U.S. Court of Appeals for the First Circuit. The reason that that's important is that this doesn't end with Donald Trump. There are many other people in the United States Senate and the United States Congress that aided and abetted the insurrection and the attempt to overturn the election. And I think they see the writing on the wall. They know that once we get Trump, they know their ass is on the line and they're next. And I can promise you that there are going to be more Castro v. a lot of people that decided that they thought that it was appropriate to try to overturn a democratic election, a fair and free election in the United States. And I'm going to continue to be a thorn on their side. Yeah. So that is the reason why I'm not giving up on my cases, because I want to get a decision from the U.S. Court of Appeals to the First Circuit and multiple other circuits clearly delineating how someone can establish standing to bring a constitutional eligibility challenge against all of the insurrectionists that were involved in January 6, 2021. So it doesn't end with Trump. Trump is just the first one. It's going to be the big one, right? Like we cut the head off the snake, but that another head can grow back in its place, and we're going to make sure we go after the rest of that and completely uproot this cancer out of the Republican Party.
Yeah. So I wanted to ask the question as it relates to the Colorado case, because many people are arguing, and I was watching CNN yesterday and some of the political shows yesterday and today, and over the past couple of weeks I've been reading the papers, and they've been saying that, well, President Donald Trump did not commit an insurrection. There is no proof, there's no evidence, no court has found him guilty of an insurrection. So therefore, as it relates or pertains to him violating Section 3 of the 14th Amendment, they're saying that the justices will weigh heavily on that. It has not been shown or proven. Can you clarify that? Because there are even some people who say that we are challenging Mr. Trump, but there is no determination by a court to say that he didn't do anything wrong. So help us with that.
Yeah, absolutely. So this is and I've seen people like that on TV, and this is the problem, right? Like CNN always goes to their quote unquote experts who honestly don't know crap about the history of Section 3 of the 14th Amendment. I hear them talk, and it's painful because you can see how ignorant they are, but they've convinced a few producers at CNN they're intelligent, and so that's why they're on television. But the truth is that they don't know what the hell they're talking about. So I'll explain a little bit of the background on this. Here's the truth. So insurrection, there is a criminal statute for that, right? 18 USC, I can't remember the exact citation, but it's there listed as a criminal statute. But here's the truth. Trump cannot be indicted for insurrection. Yes. And that's what a lot of people don't know. Because
could you say this again? This is major. Trump cannot
be legally indicted for insurrection. Even if he directly bashed one of the windows and went in there and chanted to hang Mike Pence, Trump cannot be indicted for insurrection. And I'll explain why.
Yeah.
What Section 3 of the 14th Amendment did is it decriminalized insurrection and rebellion. What happened after the Civil War was over is senators were debating, and they were saying, guys, what do we do about all the officers and all the enlisted people that fought and killed American Union soldiers? Right now, under the U.S. Constitution, they're guilty of treason. They have to be arrested, court-martialed,
Right.
and shot or hanged. Every single one of them.
Right.
And so they said, well, obviously we don't want to do that, right? Like, this is post-Civil War reconciliation. We want to try to bring the country back together again. It's not going to look really good if we hang everybody. And so they said, okay, look, the treason section of the U.S. Constitution says if you aid any enemies, foreign or domestic, you're guilty, right?
Yes.
So they said, we want to bifurcate that. We want to bifurcate foreign from domestic. So if you aid a foreign enemy, yeah, for sure, you're going to be hanged. But if you aided a domestic enemy, like the Civil War, the rebellion, the Confederates, then we are going to treat that differently. Although it does fit the definition of treason, it's like domestic treason. And so we're going to call it insurrection or rebellion. And we're going to limit the penalty to a lifetime ban from public office. But that's the only penalty they can apply. So when they passed that, and Jefferson Davis at that time, who was the president of the Confederacy, he was standing trial for treason. His lawyers immediately said, objection to the entire case. This case needs to be dismissed because Section 3 of the 14th Amendment already provides my client, Jefferson Davis, with a self-executing penalty. So to now charge him for treason violates double jeopardy because Section 3 of the 14th Amendment decriminalized domestic insurrection and rebellion, and the only penalty is a lifetime ban from public office. That's why Jack Smith hasn't indicted Trump or literally any other elected federal official, Ted Cruz, Senator Hawley, all of them. He legally cannot because insurrection was, again, decriminalized for people that took an oath of office. So that being said, that's why there has been no adjudication, criminal adjudication. Now, as far as civil adjudication, he has. He went to Colorado District Court at the lower court level, and they considered all the facts and evidence, and a judge found him civilly guilty of engaging in an insurrection. And that was, but then she said, well, I don't think Section 3 of the 14th Amendment, I don't think the president qualifies as an officer. And so that was the only legal question that went to the Colorado Supreme Court. And they said, no, there's been many Supreme Court cases, and I cited to 12 of them, that said that the president of the United States is the chief executive officer of the United States government. And so it does apply to him. And they said, oh, well, in that case, they already said that he is guilty of engaging in insurrection. Now that it applies to him, then has a lifetime ban from public office. So there already has been a civil determination of liability. And so now that's
one thing I just wanted to interject because as it relates to, I've heard the argument. There are those who argue that, well, Section 3 of the 14th Amendment will not apply because he is not a chief executive officer. He's not an officer. And I push back. But so I know you said it, you mentioned, but could you say that again for persons? Because I've heard many people on several shows talking about the fact that he is not an officer, it doesn't apply to him, but you're saying, no, it actually does apply to him.
Yeah, because we have to look at the time frame when this Section 3 of the 14th Amendment was enacted. Well, not enacted, but when the amendment was ratified and put into force and effect. We were just coming out of the Civil War. Everybody looked at many people still called Abraham Lincoln, obviously, the president of the United States. But you have to remember, we just came out of a Civil War. We were in militaristic mode. And so everybody viewed the president at that time, Abraham Lincoln, as the commander-in-chief of the Union Army. And he was also the chief executive officer of the government. They had to make that clear, to make it clear to the generals that Abraham Lincoln was in charge of the battlefield, right? Okay. Like, yeah, Ulysses Grant had the 4 stars, but the ultimate officer is the president of the United States. And so that term was added in there. And of course, people have leached onto that now to try to say like he's not an officer, right? Because officers refer to like political appointees and things like that. But again, there's even floor debates with senators. And one senator had objected because the first draft actually mentioned president and vice president. And then the final draft didn't. And so one senator objected and said, I just want to be certain that this applies to the office of the presidency of the United States. And another senator said, he quoted the Section 3 of the 14th Amendment, said, any office, civil or military. It can't be more clear than that. And so the senator said, okay, I withdraw my objection. That was the senators basically agreeing, like, yeah, dude, it applies. Like, come on, we can't list everybody. We can't say, oh, and then also the Secretary of the Treasury and the Secretary of this. I mean, it's just like any office, civil or military under the United States. You know what I mean? And then they threw in a couple of other examples. So it's a pretty lame argument. And also to say that the framer said, if you're an insurrectionist, you can't be a senator or a representative. But yeah, you can definitely be president. That doesn't make any sense. Like, you know what I mean? So the legislative intent, and the reason why these debates between the senators are important is because this legislative intent is always important when you're analyzing the law. I know this because I'm a tax attorney. And whenever we are reading a tax provision and we're trying to understand it, you have to go to the floor Senate debates to see what they were talking about, because that's going to let you know what Congress as a whole was kind of thinking when they enacted this, because that's going to let you find what their true intent was, right? And that way you go to the spirit of the law. What were they trying to effectuate here? There was no intent to allow the president of the United States to be an insurrectionist and to engage in an insurrection against his own government and then be reelected and reinstalled, into the White House. That is ridiculous. So it's a pretty pathetic argument. Everybody that has anybody that has any respect in the constitutional world that has looked at this looks at that and knows that it's bogus. I will actually tell you what Trump's strongest argument is, because I love playing devil's advocate. That's why my law practice has been very successful. I'm always able to think ahead of my enemy and know what they're contemplating, what they're thinking. So here's Trump's best argument. It's not the officer stuff. The self-executing part, if the Supreme Court tried to hang their hat on that, because there's case law going both ways, it's going to be very, very, very weak. But I'll get into that as well, Section 5. But their strongest argument is this. If the Constitution said, if you commit murder, you cannot be president of the United States again, what happens if somebody's arrested for conspiracy to commit murder? You bought the weapon, you hired the hitman, you paid the hitman, but everything stopped before it happened. You were charged with conspiracy to commit murder, but you didn't actually commit murder. So the Constitution says that you can't serve if you commit murder, but what about conspiracy? Also, what about attempted murder? What if I shot the person, but they didn't die? Now, I'm charged and convicted with attempted murder, but I wasn't charged with murder, right? So if you do a strict textualist approach, nobody has been charged with insurrection. Enrique Tarrio, all of them, they were charged with seditious conspiracy, which is another way of saying conspiracy to commit an insurrection. But nobody was actually charged with insurrection. So, you see what I'm saying there, where it's you have to be guilty of engaging in an insurrection, not an attempted insurrection or a conspiracy to commit an insurrection. That is one of Trump's strongest arguments. The problem there is that it fails under a Supreme Court case called the Cady cases. In the Cady cases, the Supreme Court elaborated on the term insurrection. And they said that insurrection covers everything that happens before a formal rebellion. So they said the way that domestic rebellion and a civil war always starts, it always starts with farmers with basically pitchforks and torches, right? They're angry. Then it becomes violent. Then it turns into a riot. And that is the initial stage of an insurrection. And it can be armed or it can be unarmed, right? It could be just with pitchforks, bashing windows and setting fires. It can include guns. But it's always chaotic and disorganized at first. And it's not until a formal political body recognizes the movement that it becomes a formal civil war, right? So some political body steps in, let's say like the Tennessee legislature decides to formally pass articles of secession. They're leaving the Union. And now they're going to organize these people that were before just bashing windows, and now they're going to give them uniforms and weapons. Now it's becoming a formal rebellion. And so that's when you start getting, and then once there's enough states rebelling and they unite, now it's a formal civil war, right? Now it's going to be run and conducted just like a regular war. And so what they said is that everything before a formal civil war forms a part of the insurrectionary movement. And so even if it's completely unarmed and violent, the point is that it was violent and that there was a specific goal to undermine the democratic authority of the government. In this case, it couldn't be more clear. They had signs that said, "Stop the steal." This has been the biggest thing that a lot of people have missed. Stop the steal. Who's doing the stealing? the Electoral College. So their sign is literally saying, "Stop the Electoral College, obstruction of justice." Like literally their sign basically was holding up saying, "Obstruct an official proceeding." Like, you know what I mean? Their stated crime was on their sign. Okay. So in other words, it was violent. They broke windows. Obviously, one person got shot. Congressmen and senators feared for their lives. People were chanting, "Hang Mike Pence," right? If this was in the 1860s, all that was missing was the torches, you know what I mean, and the pitchforks. So yes, it was chaotic. It was disorganized, and somewhat embarrassing on their part, but it doesn't change the fact that it was an insurrection. And so the argument that it was only a conspiracy or an attempted insurrection and not an actual insurrection flies in the face of the way the Supreme Court has already defined an insurrection, which is that the conspiracy is what starts the insurrection. The conspiracy transforms into an attempt, and then the attempt is either successful or unsuccessful. And usually if it's successful, then political bodies start getting involved, they start getting organized, and then it becomes a formal rebellion. But in this case, it started with a conspiracy. Then there was an attempt, and the attempt utterly failed. Okay. And so now they're trying to brush it off as saying like, well, it never transformed into an actual full-scale insurrection. Well, yeah, because you guys suck and it failed. It doesn't change the point that you freaking tried. And it doesn't change the point that the intent of the framers of the 14th Amendment made it clear that now none of you guys should ever be in public office again for having supported and attempted something like that. So
how would you respond to people who are, well, Chris Christie believes that the people should decide, Colorado should be making up their minds about, and there are those who argue that, well, there's a fourth branch of government, which is the people. And if the people are willing to overlook that and re-elect Donald Trump, then probably that should be considered as well. The court, it shouldn't go to the court. Well, how would you respond to that?
My response to that would be like, I don't care how popular Arnold Schwarzenegger is. I don't care if 99% of the American people wanted Arnold Schwarzenegger president of the United States. You do not have that option, period. You have to be 35 years old, 14 years a resident. You have to be a natural born citizen and never committed insurrection, period.
Very good argument.
Yeah. And also checks and balances, right? Like the fourth branch of government, the people, look, the legislative branch, there have been laws passed by Congress that the judicial branch declares unconstitutional. Sorry, right? Doesn't matter how many people voted in favor of it. Oh, but look, all these senators voted for it. It was a vote of 80 to 20. You know what I mean? Like it was super majority. It doesn't matter. Ultimately, the Supreme Court can step in and say, sorry, guys, we don't care what the people want. We don't care what Congress said. This law is unconstitutional, period. And it's the same here. It doesn't matter how many people want Arnold Schwarzenegger. I would vote for Arnold Schwarzenegger if he ran for president. I think the guy's cool. But I know that I shouldn't be given that option because it's not in conformity with the United States Constitution. And again, everybody wants to say they're pro-U.S. Constitution until it's time to enforce the U.S. Constitution in a way that doesn't fit their political views. And in this case, they want Trump so bad, right? They want their fat orange Jesus to be president again, that they're willing to completely ignore the U.S. Constitution and say, oh, well, the will of the people. I'm sorry. There's been many times where the will of people has been overruled by the U.S. Supreme Court because it contradicts the U.S. Constitution, and we have to stick by that.
Yes. Wow, that's a powerful argument. And what are the chances that the Supreme Court will overturn or will agree with the lower court concerning Donald Trump being barred from running in Colorado?
I mean, I think it's pretty. So we have a number of things that are very clear. Well, number one, it's an insurrection. They're already boxed in. The Katie case has already established that. So what happened on January 6th was an insurrection. No question about it. We know that Section 30 of the 14th Amendment applies to the office of the presidency of the United States. There is no respectable legal position that's contrary to that. So we know that it applies to him. We know what happened. The only way the Supreme Court could get out of this is some sort of procedural trick. Now, they could try to cite the election clause to say that no state can pass judgment on a national candidate because it has to be only for senators or representatives, like the election clause states. But they would still have to express an opinion at that point, right? Because then they would be admitting that the federal judiciary is the exclusive domain. And it's like, okay, well, you're the ultimate voice of the federal judiciary, so express an opinion. But at that point, they could argue that nobody with standing has brought a claim, and that would only leave my cases left. So there's that potential route that they could possibly do. Now, my hope, and the reason why I say that is that if they don't find a procedural way to avoid getting to the merits, then the only thing left for them to do is to get to the merits. And if they get to the merits, Trump is off the ballot. Now, personally, we know that it's a 6-3 supermajority, right? So we know the three liberals, how they're going to vote. So Ketanji Brown Jackson, Kagan, Sotomayor, we know that they're going to vote and they're going to basically find Trump ineligible. So what it really comes down to is, of the 6 other ones, we need 2 votes, only 2 people to join the liberals, and then it'll be a 5-4 decision. So who from that 6 are going to cross and join over? John Roberts, 100% for sure. I can just guarantee you that he's definitely on going to join the liberals. The other person is going to be Gorsuch, and the reason is that Gorsuch already ruled when he was on the 10th Circuit. He ruled that state elected officials can make determinations of eligibility of candidates. Now, he could argue that he meant only state level candidates like representative, congressmen, congresswomen, and senators. But the thing is that Gorsuch is a libertarian. He's conservative, but he's a libertarian. Libertarians are very fearful of strong executive power, especially by politicians who have already expressed a willingness to abuse that power. So, and then when you also think about it, Kavanaugh, Amy Coney Barrett, and Gorsuch all know that they kind of have this stain on their nomination, right? It's the Trump stain, the orange stain. And they would want to rid themselves of that stain and forever establish their independence and their disassociation from the man that put them on the bench for life. And this would provide them with that opportunity to prove to the American people that, look, I am a fair and independent judge. I just disqualified for life the guy that put me on the bench for life. So for Trump to think that because he backed them and put them on the Supreme Court, that they're going to do him a solid and keep him on the ballot, he does not understand the shrewdness and the Machiavellianness of politics, which is that this is a perfect opportunity for them to curry favor with the left, because that's where they're hurting, right? They're losing a lot of respect from the left with some of their extreme right-wing rulings that have come out. And this is the perfect opportunity for them to, again, establish that balance and their perception with the general public by getting rid of somebody that to them is not important. So I think I think Trump is screwed, personally. I think ultimately Amy Coney Barrett may side with Trump, but I think Kavanaugh may actually consider joining the liberals. And so it may end up being a 6-3 decision with Thomas Alito and Amy Coney Barrett. But I think those are those 3 that I mentioned right there: Amy Coney Barrett, Thomas, and Alito. Those are going to be the hard ones. But I know that Chief Justice John Roberts is going to try to push them really hard. Like, look, guys, if we're going to be disqualifying the leading Republican candidate, it needs to be a unanimous decision, or at least close to a unanimous decision, as close as we can get. But I know Alito. Alito is a very shrewd and calculating person. He's already made his mind, and he's going to construct the law to support his position. Thomas, I think Thomas is in a tight spot right now. I think he may end up siding with the liberals. I think there's going to be some sort of a negotiated part on his part as well. But I think there's a lot more at play here that a lot of people don't understand. You know, he's facing a lot of tax issues as well, and I think ultimately he's effectively going to be just cornered into having to vote with the liberals. And I don't know. I don't know about Amy Coney Barrett, but like I said, even if it was 6-3, you know, it's still going to be a very powerful decision. The fact that 3 conservatives crossed over, joined the 3 liberals, and sent a very strong message. So that's how I ultimately think it'll turn out. And conservatives aren't going to be in a position to cry foul because it's going to be two of his own appointees that rule against him.
Has this ever happened before, where an appointed, where someone voted against a president?
Oh yeah, okay. Absolutely. A lot of times. Okay. Many times throughout history, including some of Clinton's own appointees ended up ruling against him in court as well, when they were trying to determine whether he could be held or have to sit for a civil deposition, things like that. Okay. They ruled against him, and he was pretty pissed about that. But it's just kind of like, I mean, once they're on the bench, they're in charge of their own branch of government. They don't owe political loyalty to anyone. I mean, they're still going to be biased in favor of their political views, but in this case, the only view that's being tested is whether somebody that attempted an insurrection should be barred from office. And to say that a president could do that and get away with it, I mean, just imagine later if it's someone else. You know what I mean? Like in other words, would-be dictators in the future, would-be future U.S. dictators are going to be looking at this case and very carefully parsing through it to see what their power is and what they can get away with. And the Supreme Court knows that. They don't get lost in the fights that are political fights that are going on right now. They're thinking 20, 50 years from now. Just like, in the 90s, they were laying the foundation to overturn Roe v. Wade. They've been working on that for 30 years. So the Supreme Court's always playing the long game. And in here, there's no reason why they would want to make the executive branch that powerful. So powerful that it could even threaten them. They don't want that. So they would want to use this opportunity to limit the power of the executive, which they're having to do left and right with Trump's claims, right? Like it takes a crazy president like Nixon and Trump to really push the bounds of executive power to force the Supreme Court to get involved. Oh. Looks like he dropped off.
Hi, John.
Yeah. All right. So,
I am not sure what happened. To be honest, I'm not sure what happened just now.
No worries.
Computer died. The computer is working quite well. I'm not sure what happened. But
it takes a crazy president like Nixon and Trump to really push the bounds of executive power. And get the Supreme Court to step in and start putting limits on that power. So I think ultimately for the country, this is going to be really, really good. I know that the Supreme Court is seeing this as an opportunity to put a lot of caps on executive power, like Trump claiming that he's totally immune from criminal liability, that he's immune in the E. Jean Carroll case from civil liability. You're basically trying to argue that he's an untouchable king. And so I think in the long run, this is a really great opportunity. And the Supreme Court's going to see this as objectively as I do, that this is a great opportunity to finally address these issues and to really put restraints on the office of the presidency in the United States.
So, but what if they were to, what if they ruled what if they overruled Colorado's decision and decided that Trump should? What do you think?
It's a possibility. But if I was in Las Vegas, I would put those odds at about maybe 15% tops. It's very low. Okay. It's very, very low. And this is just my familiarity with the U.S. Supreme Court, how they think and their long-term chess game that they're always playing. I don't see a chance in hell that they would actually overturn the lower court decision. Because, like I said, the only way that they possibly could, the only route that I see would have to be procedural. So they'd have to say again that the election clause limits state involvement to elections for representatives and senators, and that only a federal court can express an opinion on this, and so the opinion has to be vacated, and that on that basis, none of the plaintiffs in those cases have standing, and so until somebody with standing actually brings it to the federal judiciary, they cannot express an opinion. And so that is where I see that my cases would still be relevant. And the likelihood of that happening is 15%, which means there's an 85% chance it's not going to happen. And so for that reason, I want my cases to stay active. I'm still working on them, working my way through the appellate process.
Right, and I wanted to ask you what's going on with Judge Aileen Cannon and the case in Miami, and the case with Judge Reyes in Arizona.
Yeah, so you left again.
John, I'm not sure what's going on with my I'm not sure what's going on today.
No worries. I can just jump in and continue.
To be honest, it's my computer is fully charged and working. Everything is fine. I'm not sure what's going on, but we're talking about
no worries. So
interesting matters, and I was asking about to give us an update as it relates to Judge Aileen Cannon and the recusal of her. What's going on in Miami, Arizona, Judge Reyes, so on and so forth. Yes.
Yeah. So the 11th Circuit in the Aileen Cannon case just never ruled, and the reason for that, I've seen this time and time again. When they're cornered and checkmated, they choose just not to rule. So they just usurp judicial power and just decide not to issue a ruling because that's been pending all year. But and it's because there's no question she has to recuse. But if she recused in my case, then she has to recuse from the Jack Smith case, and so they're just not going to ever rule on that, probably until after the election, because they're a bunch of corrupt POSs. But in Arizona, that case got appealed to the U.S. Court of Appeals for the 9th Circuit. Same deal. They know that the judge's reasoning can't be upheld. He said that I was running in bad faith to disregard my injury, but no court has ever held that. And so they know that they can't uphold that based on their case law. So they're choosing not to rule until March 28th after the Arizona primary. But then when they hear the case, they're going to say, oh, but it's too late now because it's moot, even though I objected on that basis.
Yeah.
And so they'll just end up dismissing the case and never ruling on it.
Wow,
so,
this is quite interesting.
Yeah, it's rigged. It's rigged. Like
yes.
What I found is that when they want to avoid ruling on an issue, they will break they'll violate my First Amendment rights, and they'll just completely do whatever they want. And it's one of the flaws with, a government of the people, because people have their biases and their prejudices, and when they don't want to do something, they won't. And I'm seeing that firsthand, that I have them legally checkmated, and ultimately they can just get up and walk away from the game, and I can't force them to make a move. Technically, I could petition for a writ of mandamus with the U.S. Supreme Court to try to mandamus the 9th Circuit, but again, that's discretionary. There's nothing in the law that says the Supreme Court has to issue that. So again, I've ultimately found that the federal judiciary is pretty crooked and corrupt. But they can't ignore it forever. Yeah. And if I have to devote the rest of my life to this, I will, because I view it as incredibly important. There has to be a way. See, because what the judge in Arizona effectively said is that I was acting in bad faith by manufacturing standing. But if that judge had been around in the 1960s, when the Southern Baptists walked into those segregated restaurants that said whites only and sat down, and then they called the police and dragged them out, beat them up, sent them in jail for criminal trespass, that judge could have also said, That person did not go into that restaurant in good faith to eat a meal. He went in there in bad faith to voluntarily incur an injury, to self-inflict an injury, in order to manipulate the federal judiciary and manufacture standing in order to challenge racial segregation laws. And because he incurred that injury in bad faith to try to manipulate our American court system, we're going to say he doesn't have standing to challenge racial segregation laws. That's exactly what that judge is effectively saying.
Yes, definitely.
And the thing is that civil disobedience and taking a stand based on principle is a time-honored American tradition. We should be encouraging Americans to take a stand on principle, not saying that they're acting in bad faith. And what I found very ironic about that is that if I was running for office to enrich myself, to enrich my family, and to advocate on behalf of all my corporate sponsors, and all the corporate oligarchs that were backing me, that would be good faith. But if you're running for the presidency to enforce the Constitution and you're doing it on principle, that's bad faith. Think of how Orwellian that is, that if you're doing something with evil intent, it's good faith. If you're doing something with pure intent, it's bad faith. That to me was absolutely mind-blowing. And again, that's why the Ninth Circuit doesn't want to hear this case, because they're like, guys, if we hear this case, there's no way we can uphold what the Arizona judge said. And so we'd have to reverse the Arizona judge, and then Castro would have standing and he'd make it all the way to the US Supreme Court. And they don't want to do that either, because they want Trump to be the nominee, because although it's a liberal circuit, again, they know Biden can beat Trump, but Biden might not be able to beat Nikki Haley. And so again, that's why they actually want Trump to be the nominee, and they're choosing to just kind of stay out of the fight. And so, but in doing so, violating my First Amendment right to have my case heard at the appellate level. But again, it is what it is. They think that my only goal is Trump, but this isn't the last they've heard of me. Once we're done with Trump, like I said, we're going after everybody. And so I'm going to be back in the federal courts again, and they're going to be confronted again with the standing issue. And I'm going to keep doing it until they do their goddamn job, which is to issue a ruling without fear or favor. Issue a ruling based on what the law is, and they know that the law says that I have standing. They're just, again, trying to invent any and all possible legal grounds to try to dodge it. Oh, you're on mute.
So as we get ready to wrap up, I wanted to ask you, give us an update in terms of what's going on with your campaign. Are you on the ballot for New Hampshire?
Mm-hmm. Oh, okay. Yeah, I'm still on the ballots of New Hampshire, Arizona, and Nevada.
Okay.
We're exploring ballot access in other states only to the extent that is that's necessary for the objective of the campaign. And again, I've said this before in open court, and I'll say it again. Yes, there are many campaigns in the past that some people have ran almost entirely on the Second Amendment right to bear arms. Yes. Other people have ran almost entirely on the 14th Amendment right to equal protection, right, against racial segregation. Or more modernly, running their campaign on the 14th Amendment right to gay marriage, equal protection under the law as well. I'm running under Section 3 of the 14th Amendment. But that right away, they blow the whistle and they say, well, that's not a real political issue. Really? Because I think it's the political issue of our generation of how this particular provision operates. It's going to sleep.
Great, you're still there. I don't. Yes, you were making a profound point. I hope you still remember that point.
Oh yeah. So yeah. I mean, every campaign
try to block me and turn my computer. I think I'm dealing with a lot of spyware and attack. I've been under a lot of spyware. I am doing a lot of sensitive news. I talk about powerful, deep stuff. and content creators are under a lot of attack. My system is probably under a lot of attack, but we continue to push through despite all of the challenges. But yes, you're making a powerful point.
Yeah. So again, every campaign can run on different aspects of the U.S. Constitution. Some campaigns build entirely under the Second Amendment right to bear arms, others under the 14th Amendment right to, gay marriage and equality under state law. I say that my campaign is all about Section 3 of the 14th Amendment, and people blow the whistle. That's not a real political position. And it's like, what? So, who are you to say what is and isn't a valid position? And again, the fact that I've spent less than $50,000 and achieved global media coverage, made Section 3 of the 14th Amendment mainstream news, and my name is known in every corner of the country now. To say that this isn't a political issue, I would disagree. And so I have said it before, and I'll say it again. My campaign is based on constitutional principles and enforcing the U.S. Constitution, in particular, Section 3 of the 14th Amendment. That is a valid political position. And the fact that I'm also litigating in courts is irrelevant. But they've tried to, again, use that as a basis to say that, oh, no, your whole campaign is just about disqualifying Trump. And it's again like, well, Trump's whole breakout movement was just trying to force Obama to release his birth certificate. Nobody challenged that. So again, everybody has their breakout moment. You have to have a strategy. How am I going to be recognized? How do I rise above the competition and get noticed? And the fact that I've been able to achieve all of this with such a minuscule amount of resources is, nothing short of political strategy greatness. It's not going to stop here. There's going to be other people that we continue to go after in the future. And we're going to make sure that we determine what is the full scope of Section 3 of the 14th Amendment. What does it mean to provide aid or comfort to an insurrection? And so we're going to continue pushing this.
Nobody knew about it. I didn't know much about it either until we started this show about a year and a half ago or something like that. But you have brought the attention of everyone. in a sense, when I talk about, when you look at what you've done and your success, how people measure success, part of our responsibility is we have to hold people responsible and accountable. And I think you have done that in a quite powerful and unique way.
Yeah. So it's been very interesting, but like I said, the future of the campaign, ultimately, if the Supreme Court steps in, if they disqualify or if they issue a ruling on the merits, I would feel like at that point that my campaign and its objective as far as enforcing Section 3 of the 14th Amendment is completed. And then I'm going to be looking to the future to decide what other senators and congressmen were involved. Does their involvement reach the level of providing aid and comfort to the insurrection? And trying to determine whether there are grounds to then challenge that person, in their particular state. So this is just the beginning. The way that I view this is kind of like after World War II, you had the Nazi hunters, right? They didn't let up. And it's just like, I don't care if I have to go to the far ends of the earth, I'm going to find you and I'm going to hold you accountable. And so this fight's probably going to go on for the next 10, 15, 20 years. And but we're going to get them all.
Yes. And, I wanted to one last point, and probably a point that maybe you could comment is where is this country headed? Earlier I was having a conversation with a student about the difference between democracy or democratic nations and totalitarian nations. And I said, one of the things I talk about was, totalitarian nations and countries, they don't hide. They don't hide behind strategy. They just tell you like it is. Countries that are democratic these days and supposed to be the example, it's as if they are still totalitarian, but we wear the name democracy. Because we do the same thing that totalitarian governments do, but we use strategy, certain and institutional arrangements and so on. Because for example, what you are trying to do in terms of holding Mr. Trump accountable, but we are finding ways where the judiciary, Congress and so on and so forth are finding various loopholes to protect the most powerful in this country. What does it say about what Americanism and what we stand for in terms of freedom? And say, for example, you as an American, which gives you the right to run for office. They're trying to make and to challenge leaders. They're saying that, oh no, you're not a real candidate. You're a nominal candidate. So you're not really, and you're not a real candidate. I mean, what does that say about America and where we're headed today?
It's tough and it's scary, but here's the thing: is this is democracy 2.0, right? We had democracy 1.0 with the Greeks and the Romans.
Yes.
And this is, I mean, think about it. Like, we were just getting out of the monarchical period, from what, like the year 900 to 1700.
Yeah.
And this was the first democracy. And we created the Constitution plus the first 10 amendments. Since then, we've added, about 13 more amendments or so. It's democracy 2.0. And I think that, in the future, 500-600 years from now, when democracy 9.0 is looking back, they're going to look back and be like, man, remember when we really screwed it up on 2.0? We let the country descend into an oligarchy, and we underestimated the willingness of wealthy people to buy the legislature, to corrupt the Supreme Court. I mean, it was FUBAR, and so I mean, there's a lot of things that are wrong, and but we're going to learn. We can't expect all that change overnight. There are those of us that study democracy and government, and we know how archaic our current structure is, right? Because I'm already thinking 400 years from now and looking at us, and I'm like, oh my gosh, it's so corrupt and it's so easily manipulable. But I know that in the future, we're going to rewrite our judiciary in a way that's more fair. We're going to rewrite our legislative branch in a way that's more fair. But it's going to take time. Like right now, the ridiculous cap that we have, 345 Congress members. A lot of people don't know this. The U.S. Constitution actually says that one congressman should not represent more than 30,000 people. Yet right now, it's one person representing 750,000 people.
Yes.
But the thing is that nobody knows how to enforce that provision of the Constitution that limits a congressman. So right now, in other words, we should have probably 5,000 Congress members. But the thing is that we built a Capitol that only can seat 345 people. So we were like, let's not add any more. It's going to make it complicated. And so, again, we've gotten to this ridiculousness where we've gone against what the framers said, that it shouldn't be more than 1 to 30,000, and now it's 1 to 750,000. And then we wonder why our members of Congress have lost touch with the people. Yes. How the hell can you possibly represent 700? And even then, the framers of the Constitution were debating whether 1 to 30,000 was too much. They'd be turning in their grave to see that we're at 1 to 750,000 right now and wondering why we ignored them when they explicitly put that in the U.S. Constitution. And a lot of people don't believe that, but just, you'll be able to find it. I don't remember the exact provision, but look it up. It's in there. Our framers never wanted it to exceed 1 to 30,000, and right now we're at 1 to 750,000.
Oh, that's something that we have. Probably that's another discussion.
It is.
Yes.
A very important discussion, but in the future we'll likely have it that way, to where it'll probably be somewhere like 1 to 15,000 or something like that, and then you'll have one person representing every maybe every 3 or 4 neighborhoods or something like that, and that gets you closer to direct democracy, right? When it's just like, oh well, I know this guy, he literally lives in the neighborhood next to me, you know what I mean? And that would be a more representative democracy than what you get right now. And it's no wonder why these congressmen and congresswomen will only listen to millionaires and billionaires. I mean, because even then they have their hands full just trying to listen to those people. So, which means that people like us don't stand a chance. So, I mean, like I said, we're democracy 2.0. But we're getting there little by little.
Yes. Well, thank you so much. This was amazing. Despite the challenges, you stuck with us. You stuck with it. I appreciate that. And I did read your read an article by in law.com, I think, and yes, that was really beautiful. And but we wish you all the best. We want to thank you so much for contributing to the NeoLiberal Round Podcast, and we will continue to do shows like this. As I said, we're all about making popular what was the monopoly. We're all about serving the world today to solve the most challenges by making popular what was the monopoly. Visit us at theneoliberal.com and RenaldoMcKenzie.com. And my new book is about to drop, written by me and the famous Mr. Professor Martin Oppenheimer. I'm looking forward to releasing that book. You guys get a copy when it comes out. And I'm looking forward to be on Georgetown. I start back at Georgetown tomorrow. I'm looking forward to that and working, and then I'll be teaching Caribbean thought. But visit us at theneoliberal.com. Support us at anchor.fm/theneoliberal/support. And remember, you can support Mr. Castro by going to johncastro.com.
Yep.
And you can follow him on Twitter at John A. Castro. Thank you so much, What Good. Take care, brother. And
we'll take care, brother.
Yeah, man. I appreciate it. Bye-bye.
Bye.
Yeah, man.